subject of disqualification. What I'll do is introduce our speakers in the order that they're going to speak. And after they each offer their comments, I'll give them a chance to see if they want to ask questions or make comments to one another, and then we'll open it up. To questions. So we're going to start with Professor Kurt Lash. He is the E. Claiborne Robbins Distinguished Professor of Law at the University of Richmond, where he teaches and writes about constitutional law. You'll find a longer bio on the website for the conference, but I just want to highlight that he's written extensively on the 14th Amendment, including a book, The 14th Amendment and the Privileges or Immunities of American Citizenship. And he's also published a 2-volume collection of original documents relating to the framing and ratification of the 3 Reconstruction Amendments. We'll next hear from Professor Derek Muller, who's a nationally recognized scholar in the field of election law. His work focuses on the role of states in the administration of federal elections and other issues relating to voting rights and election administration. He's published widely, testified before Congress, and is a contributor to the Election Law blog and a co-reporter on the Restatement of Law Election Litigation. Last but not least, Professor Mark Graber is the Regents Professor at the University of Maryland Carey School of Law. He writes on constitutional law, constitutional development, constitutional politics, and as he says, pretty much any other topic in which constitutional is used as an adjective, which is a very Mark kind of bio, I think. So we'll start with Professor Lash.
Thank you, Jane. Good morning, everyone. A pleasure to be here. Thanks to Michael McConnell and the Stanford Center on the Constitution for inviting me to be part of this panel in this conference and to have another round of debate with Derek and Mark about Section 3. We've gone back and forth over the past several months. It's kind of odd to be talking about a provision that a year ago no one knew about, and 6 months ago everyone was writing about, and today most people have forgotten about it. At least for the moment. I of course think we should remember. We should remember Section 3 and go on thinking about it, not just because it's historically a part of the vastly important 14th Amendment, but also because it still may be in play. We still may be talking about Section 3 maybe in a few months around the time of January 6th. So if Congress tries to disqualify votes for Donald Trump at that time, the case is going to go right back to the Supreme Court, where it most likely will be decided by the same majority that wrote the per curiam opinion in Trump against Anderson. So it's worth, I think, pausing for a moment and taking a look at that opinion and maybe see what it tells us about possible litigation, possible future litigation. The majority opinion, the per curiam opinion, closes some doors but leaves others open. Actually, it leaves a lot of doors open, including, I think, whether the office of the president is covered by the text at all, and whether freedom of speech limits limit what counts as engaging in insurrection or rebellion. The closed door that I think we'll have a discussion this morning about involves enforcement in the absence of congressional legislation. I think Derek may disagree, but I think that that's actually a done deal, and I'll explain my reasons for that, and we can have a conversation as we go. The court, in that lead opinion, I think left some clues about where we might go in the future. So what I want to do is I want to dig into the per curiam opinion and talk about its reasoning, and in particular focus on where it departs from the reasoning that was presented in most of the pro-disqualification briefs. So I'll briefly introduce Section 3 for the uninitiated, and then I'll dive into the opinions themselves. Okay, Section 3 of the 14th Amendment. The 5 sections of the 14th were primarily drafted in the early months of 1866 by the 15 members of the Joint Committee on Reconstruction. Section 3, however, of the 14th Amendment is an exception. That section was added at the last minute after the House had already approved the Joint Committee's original draft. Section 3 of the original draft prohibited rebels from voting for federal representatives or for presidential electors until the year 1870. This provision was broadly criticized by both Republicans and Democrats, with critics inside and outside of Congress pointing out that states could easily evade its restriction on electors by simply choosing to appoint electors rather than electing them, which some states like South Carolina already did. The House accepted the partially flawed proposed amendment, but the Senate Republicans wanted changes. So they decided to meet in a private caucus where they tasked a small subcommittee with coming up with a better version of the amendment. And the result a few days later was the addition of the citizenship clauses to the opening of Section 1 and a completely new version of Section 3. This new version banned former rebels from holding certain offices rather than banning rebels from voting for certain offices. And for those who haven't memorized the text, it's worth quoting. No person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid and comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability. All right, there's the text that they cobbled together in a few days. And there are a lot of mysteries there. Why, for example, does the text expressly name representatives, senators, and presidential electors, but does not expressly name the office of president? What counts as an insurrection or a rebellion? And finally, is the provision self-enforcing, or does it require congressional legislation by way of Section 5? Now, the court's decision in Trump against Anderson left most of those questions unanswered. All 9 justices agreed that it was constitutionally inappropriate to allow the states to disqualify federal officials. But that's a structural federalism point, and it has little to do with the actual text and meaning of Section 3. That, of course, is a feature, not a bug, because it allowed the court to issue a unanimous opinion on a politically divisive case. Part 2B of the per curiam opinion, however, went beyond this basic structuralist point and engaged in the actual history and meaning of Section 3. And it did so, its authors explained, because there were a number of reasons why they thought the Colorado court had erred. The structural point was only one, and as far as we know, to the majority, it might have been the weakest of the points, since it was based on general principles and not on the original understanding of the text. In Part 2B, therefore, the majority presented the first originalist account of Section 3, and in doing so, they declared the fundamental or first principles of Section 3. And it's worth quoting those basic principles because they're laid out right at the beginning in the first 2 paragraphs of the per curiam opinion. So again, to quote, proposed by Congress in 1866 and ratified by the states in 1868, the 14th Amendment expanded federal power at the expense of state autonomy. Then, Section 1 of the amendment, for instance, bars the states from depriving any person of life, liberty, or property without due process of law or denying to any person the equal protection of the laws. I'm omitting the citations that are in that paragraph. Next paragraph. Section 3 of the amendment likewise restricts state autonomy, but through different means. It was designed to help ensure an enduring union by preventing former Confederates from returning to power in the aftermath of the Civil War. Okay. In those excerpts from those first 2 paragraphs, the majority declares that Section 3, like the rest of the 14th Amendment, restricts the actions of the states. This is an understanding of Section 3 that is quite different from that presented in the briefs of the disqualificationists. Disqualificationists generally describe Section 3 as restricting bad people. The majority describes Section 3 as restricting bad states, and these are not the same thing. Bad people are individuals, like problematic presidential candidates. Bad states are collective actors. Bad states pass the black codes or elect former rebels to Congress or to the state legislature. And as if to underline this concern with state-level collective actions, the second paragraph in the per curiam opinion then cites two specific examples of what Section 3 was designed to address. First, they cite Thaddeus Stevens' quote, warning that without appropriate constitutional reforms, yelling secessionists and hissing copperheads would take seats in the House. Next, they cite Senator Jacob Howard, who, quote, lamented the prospect of a state legislature made up entirely of disloyal elements absent a disqualification provision, end quote. These, then, are the model examples of the targets of Section 3, and they support the majority's insistence that Section 3, like Section 1, was about restricting the actions of the states. And if the majority is right, that the framers of Section 3 were focused on pro-rebel local elections, then that could explain the otherwise odd omission of the office of the president in Section 3's opening enumerated list of protected offices. That sentence expressly names offices selected by state majorities, and it leaves out the nationally elected office of the president. During oral argument, my favorite part of oral argument, during oral argument, Justice Jackson focused on this opening text. Justice Jackson pressed Trump's lawyer, Jonathan Mitchell, to address whether Section 3 was about national presidential elections or instead was focused on, quote, senatorial elections, representatives, the sort of more local concerns, end quote. Twice she asked Mitchell to address whether, quote, Section 3 was about preventing the South from rising again in the context of these sort of local elections, as opposed to focusing on the presidency, end quote. And Justice Jackson specifically pointed to the text of Section 3 as seeming to reflect this focus. Again, to quote Justice Jackson, why didn't they put the word president in the very enumerated list in Section 3? And then a little later on, I guess that just makes me worry that maybe they weren't focusing on the president, and for example, the fact that electors of vice president and president are there suggests that really what they thought was if we're worried about a charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise, end quote. Justice Jackson, I'd like to think, had read my brief. Unfortunately, Trump's lawyer had not, and he trotted out the exchange in the Senate where a member, which Mitchell incorrectly named, tells Reverdy Johnson that the presidency is actually covered. Justice Jackson wasn't impressed with that response. Even if one or two senators thought the presidency was covered, quote, doesn't that at least suggest ambiguity, end quote. I think Justice Jackson is right. It does at least suggest ambiguity, as I explained at length in my forthcoming article in the Harvard Journal of Law and Public Policy. Now, whether Justice Jackson actually held this view herself, or whether she later changed her mind, it's impossible to know. What we do know is that 5 justices described the amendment as focused on decision-making at a local level. And by doing so, whether they meant to or not, the per curiam left open the door to eventually ruling that Section 3 restricts the state choice of electors and not the nation's choice of president, or that the text, at the very least, remains ambiguous on that point. If and when the court does that, they will almost certainly quote these opening paragraphs in Trump v. Anderson, which set up exactly that kind of interpretation. So that door remains open. The door of self-execution, I believe, is closed. Future enforcement of any kind against a federal official, I think, will require congressional legislation, or at least that'll be the decision of the court. The per curiam quotes Trumbull's, during the framing debates, Trumbull's declaration that enforcement legislation was necessary because the text makes no provision for its own enforcement. They describe congressional legislation as being critical in order to provide proper process for determining whether an accused insurrectionist is disqualified. And of course, most tellingly, the concurring justices expressly declare their understanding that the majority had closed that particular door of self-execution. That's why they concur rather than join in the majority opinion. But even more importantly, I think, is why the majority thinks that enforcement legislation is required. Pro-disqualificationists insist that Section 3 was a self-enforcing qualification, no different than the requirement that presidents be 35 years of age. The majority, however, denies that Section 3 is a simple disqualification or a simple qualification. Section 3, to quote the majority, imposes a severe penalty, end quote. Severe penalties can be imposed only upon those found guilty and subject to punishment, and this requires adequate and fair process. If you have any doubts, see the due process language in Section 1. This is why the majority describes Section 5 as critical to the constitutional enforcement of Section 3. It empowers Congress to pass legislation establishing fair procedures for determining whether or not someone is subject to the severe penalty of disqualification. That legislation, moreover, would be subject to judicial review in order to ensure that it conforms to the Bernie standard of congruence and proportionality. For example, severe penalties may be imposed only on those offices clearly covered by Section 3. It must include only those activities that meet the judicial definition of insurrection or rebellion. And finally, enforcement of Section 3 must be consistent with Section 1 and the newly established privileges or immunities of citizens to exercise their rights of freedom of speech and assembly. In other words, enforcement requires legislation because disqualification is a severe penalty that the Constitution demands be imposed according to nationally defined and promulgated standards, or at least that's how I read the majority. In conclusion, unanimity is great as far as it goes, but I'm glad that the majority went further. We don't know everything about Section 3. It's too soon. The article was published just a year ago, the Baude article?
It was posted on SSRN in August of 23.
We've been debating privileges or immunities, for 150 years? Right, okay, and anyway, it's too soon. The scholarship is in its infancy. But the history, I think, is clear in some matters. The text, like the rest of the amendment, is centrally concerned with problematic state decision-making, whether the passage of black codes or the attempts to send former rebels back to Congress. Whatever future litigation occurs in regard to Section 3, it must be consistent with those central purposes. It was also important, I think, or critical, you might say, for the court to immediately announce the need for enforcement legislation. That is not a matter that should wait until partisans in Congress try a last-minute disqualification of Donald Trump on January 6th. Neither the country, nor the court, nor the Constitution should have to endure that kind of chaos. Thank you.
Well, thank you so much for the invitation to Michael McConnell and to the center here. It's been a great conference so far. Really looking forward to the rest of it. I'm grateful that also I'm going to disagree pretty strongly with Kurt here on a number of things. So hopefully that'll give us some conversation as the day moves ahead. Trump v. Anderson, while this came to a head in August of 2023, as we start to think about the Baude Paulsen article and some of the other litigation. I mean, some of this predates this. I was filing amicus briefs in March of 2022, dealing with challenges to Madison Cawthorn out of North Carolina and Marjorie Taylor Greene out of Georgia, as related challenges were filed in state courts there. I'm going to come back to those points later in the conversation, but we can think about this as having sort of some broad structural principles beyond just the presidency, and thinking about the role of Congress as an actor in this space and dealing with disqualification. And to that end, as we read Trump v. Anderson, the Supreme Court's decision, a somewhat unanimous decision, and in some senses a failure of unanimity, right? I think the desire we want is not just unanimity in the result, but some sort of coherence to the reasoning. And I think we saw, as the court raced to get out an opinion ahead of the Colorado primary the first Tuesday in March, and releasing an opinion on Monday before that Tuesday primary, I think it reflected a lot of internal struggles and divisions in the court about the approach to take. And I think we can see that in how the concurring opinion characterizes the majority per curiam opinion, and wondering whether or not that's actually what's happening in this case. So the first point is to push back a little bit on Kurt's suggestion that, well, the dissent suggests that this must happen, or it's not dissent, but I'm going to refer to it as a dissent for a moment. The dissent suggests that rules for disqualification must occur by legislation, right? The language that the concurring opinion uses must enact legislation under Section 5 prescribing the procedures to ascertain what particular individuals should be disqualified. And elsewhere, the concurring opinion laments that the per curiam opinion has established a requirement that a Section 3 disqualification can occur only pursuant to legislation enacted for that purpose. These words, must, required, only, do not appear in the per curiam opinion. They are nowhere to be found. The closest we find a holding that legislation is required is this language that Kurt did cite. Congress's Section 5 power is critical when it comes to Section 3. If you read critical as important, it's an uncontroversial proposition. If you read critical as essential, then maybe it means that we need to have legislation exclusively. But as the concurring opinion rightly criticizes the majority, that there's it's not clear what the word critical means in this context, and yet the majority continues to use that word critical. So while there's definitely an emphasis in Part 2A of the opinion on legislation and the need for legislation and how Section 5 of the 14th Amendment empowers Congress to enact legislation, and how legislation must meet congruence and proportionality under City of Bernie versus Flores, and a whole series of things that we can think about when it comes to legislation. It's not clear to me that the majority opinion on its literal terms requires legislation. And in fact, I think there are some reasons to doubt that it does so. But let's talk about some legislation for a moment. Congress, in late 2022, enacted the Electoral Count Reform Act. This updates the Electoral Count Act of 1887. It provides some clarity for the rules for how Congress goes about counting electoral votes and how states go about transmitting their votes to Congress. After the January 6, 2021 debacle of counting electoral votes and objections to those votes, followed by the riots at the Capitol, there was clearly a need to remove some of the ambiguity that had been in existing law, that had fomented some of the uncertainty, suggesting that people like Vice President Mike Pence could just unilaterally count votes or send votes back to the states or whatever they might do. So the Electoral Count Reform Act offers some clarity and some finality in a number of respects. And there are three principal places where the Electoral Count Reform Act, and this is an act of Congress, tries to do this. One is by clarifying what election day is. Another is by clarifying that time frame and the period of time between when states hold their popular elections on election day and when electors cast their votes. And then finally, how Congress goes about counting votes on January 6th. So in that second stage, that stage of election day to the electors casting their votes, Congress wanted to provide a firm deadline and saying that states now have to finish their counting and essentially have a certificate of election in place 6 days before presidential electors meet. And then it added a venue provision to say if there are disputes that arise in the states with respect to the counting of or the issuance of certificates of election about who won your state, you can go into federal court. There's an expedited mechanism to be able to resolve disputes arising under federal law, a 3-judge federal panel with a direct appeal to the United States Supreme Court. And that was designed essentially to move disputes about due process, equal protection, 1983 concerns through the federal judiciary as quickly as possible so they could be expeditiously resolved well before the electors meet. There's been some suggestions since Trump versus Anderson that this somehow is a mechanism that might permit some way of people challenging a candidate's qualifications before the electors meet or sometime after Election Day. But there's nothing in this statute that seems to do that. Congress doesn't seem to be enforcing Section 3 of the 14th Amendment at all. Congress, in fact, almost nowhere mentions the word president. Everything is about the electors. It is about the governor of the state issuing certificates of election and the like. So this narrow provision designed to resolve pre-existing disputes, again, due process, equal protection, those kinds of things, legislation enacted by Congress in 2022, but will not provide any clarity, finality, resolution of disputes about presidential qualifications. But the real question, I think, would arise to think about what Congress's role is on January 6th, 2025. And so here, I'll sort of spend the focus of my remarks. First, I think the Electoral Count Reform Act does anticipate that Congress can refuse to count electoral votes on the basis of a presidential candidate's qualifications or disqualifications. Second, Trump v. Anderson does not constrain Congress's behavior when counting electoral votes under the Electoral Count Reform Act. Third, if Congress refuses to count votes for a winning candidate it deems not qualified, the second place candidate does not win. Instead, the election is thrown to the House of Representatives for a contingent election. And fourth, as a matter of policy, Congress should refrain from refusing to count votes cast for president it deems not qualified under Section 3 if it has failed to implement enabling legislation before the election to ascertain whether the candidate is qualified. So first is to Congress's power to count electoral votes. The Electoral Count Reform Act clarifies there are only two grounds to refuse to count electoral votes: that the certificates appointing the electors were not lawfully certified, or that the votes were not regularly given. This phrase, regularly given, appeared in the Electoral Count Act of 1887. It focuses on the behavior of electors in casting their votes. They voted at the wrong time, they voted in the wrong place, they failed to vote by ballot, they were bribed. And likewise, I've argued in other scholarship that it includes voting for or refusing to count votes for a candidate who is not qualified. So in 1873, Congress refused to count 3 electoral votes cast for Horace Greeley, who had died after the election, but before the electors met. Congress refuses to count those votes. There were other drafts of the Electoral Count Reform Act that included many more specific enumerated objections, including naming Section 3 specifically, but I think Congress viewed it not as excluding its power to use Section 3 as a basis to refuse to count votes. I think it realized that enumerating qualifications would be distracting and would distract from the underlying bill itself. So we can focus on that word regularly given and realize that the word regularly given has a deeply understood meaning stretching back to the late 19th century. Congress, likewise, in many places, has the authority to enforce Section 3 without legislation. So first, despite the fact that the opinion does, in Trump v. Anderson, emphasize this need for legislation, the per curiam opinion almost begrudgingly concedes that Congress has the power to refuse to seat a member of a House of Congress if that candidate is disqualified under Section 3. It needs to acknowledge that because there's historical precedent. It existed in the immediate aftermath of the passage of the 14th Amendment. It did not require enabling legislation, and this would have been the principal way of enforcing Section 3 under the precedents understood in 1868. It was not pursuant to enabling legislation. It was pursuant to Congress's power to judge the qualifications, elections, and returns of its own members. Second, Congress may enforce Section 3 of the 14th Amendment through impeachment. Impeachment does not require enabling legislation. And in fact, in January of 2021, as we heard about impeachment yesterday, Congress enacted articles of impeachment citing insurrection as the basis for that impeachment. No enabling legislation necessary. And likewise, I would argue under the 12th Amendment, Congress holds the power to count electoral votes. That power to count electoral votes includes a substantive power to decide what to count and what not to count. That occurs as a matter of independent constitutional obligation. It can happen by a joint rule, by a concurrent rule, or by a law, however it so decides, but it does not require enabling legislation. It is inherent in Congress's authority to count electoral votes and decide what to count. And this is, I would further argue, a judicially unreviewable power. I have a very lengthy string citation of scholarship stretching back to 1968 on this point. So if the Supreme Court is confronted with a dispute about whether Congress has counted appropriately, I would argue it's judicially unreviewable and outside of that normal bounds of judicial review. And in fact, I think we could look at the Electoral Count Reform Act and wonder, well, if this is a statute, isn't this a basis for perhaps judicial review? The Electoral Count Reform Act articulates bases for review. If there's a dispute about what regularly given means, if there's a dispute about what Congress has the authority to do, isn't it the ordinary power of judicial review to step in and interpret the statute? And I would argue that that's not the case at all, because Congress, likewise, has enacted statutes pertaining to some of its other powers under, for instance, the refusal to seat members in Congress by judging their qualifications, and those have been deemed judicially unreviewable. The Federal Contested Election Act of 1969 sets procedures for the House of Representatives about how it goes about judging disputes about elections that happen in the states. It has a procedure that it's enacted by law. But this procedure, if it chooses not to follow it, is not judicially reviewable. And just then Judge Scalia in 1986 on the DC Circuit in a case called Morgan versus United States, when a challenge is brought to the refusal to seat the purported winner of an election in Indiana, the challenge is brought by voters in the District of Columbia to say, well, the House refused to follow its own procedures. Scalia wrote, "It is doubtful to begin with, in a matter which the Constitution commits exclusively to the House's judgment, whether the House's failure to follow statutorily prescribed procedures can ever be the subject of judicial inquiry." So the mere fact that there's a statute we are looking at here with the Electoral Count Reform Act does not, in my judgment, empower the federal courts to second-guess the determinations of Congress. So a couple of sort of final points to think about this. While Congress does hold this authority, and while it has enacted a statute that constrains its authority in some way and gives it the procedures that it's supposed to use, I think there's a couple of consequences worth considering. The first is that if it refuses to count votes for a candidate, that does not mean the second place candidate becomes the winner. And in fact, the Electoral Count Reform Act offers some specific clarity on this point. That is, the electors are still appointed. They have received their commissions. They are validly appointed electors from the state. There will be 538 electors in 2025. But if Congress refuses to count votes cast for a candidate it deems not qualified, then those votes are sort of thrown out. But the denominator, 538, remains, and a candidate is required under the 12th Amendment to have a majority of all the electoral votes of the states. So you would still need 270 electoral votes. If you throw out votes for a candidate who is not qualified, does not mean Joe Biden wins, supposing he's the second place vote getter. It means that the election goes to the House of Representatives to choose among the top 3 vote getters, the remaining vote getters, which may be 1, or maybe in really creative circumstances, a series of faithless electors casting votes for other individuals, something else we could maybe talk about. And then finally, despite the fact that Congress has the power, and again, I'm a very strong departmentalist on this point, and I think Congress holds this authority, strong exclusive authority, that does not mean it is wise for Congress to step in on January 6th at the 11th hour and refuse to count electoral votes. That is, the Electoral Count Reform Act, and really the Electoral Count Act before that, is designed to constrain debate. After the election of 1876, it was very frustrating in Congress to send this to a commission, to have a commission investigate, try to determine who the true winners were in the states and so on. And the Electoral Count Act is designed to constrain Congress's discretion. It is designed to say that you are supposed to accept the votes, presume they are regularly given from the states, and then count them. And if there's a debate, you separate for no more than 2 hours of debate. 2 hours is not a long time to investigate qualifications that are not immediately obvious from the face of the election certificates or from sort of publicly available knowledge. And to the extent that somebody is convicted under the Insurrection Act or has been impeached and disqualified from office, those are perhaps the kinds of areas where Congress could step in and immediately refuse to count the votes. But given that it has only 2 hours, I would suggest it's imprudent for it to exercise its authority to sort of make these determinations wholesale, sort of in the joint session to make the determination. So I think it's worth separating the is from the ought in cases like this, and to think about what Congress's authority is and how it ought to exercise that authority in the circumstances of the 2024 presidential election. Thank you.
Well, first, on behalf of, I think, of the whole panel, we would like to thank Stanford and Professor McConnell in particular for giving these East Coasters the morning panel and not the afternoon panel. And all we can say is we promise the next conference we're involved in to give the West Coasters the 4 o'clock in the afternoon panel and not the 7 in the morning panel. There are 2 strategies for remaining in fashion. The first, and I can see who in the crowd does this, is, you set the fashions. What you wear is in fashion. The second is mine. I've worn this suit or the equivalent for 40 years, and I just hope every now and then it comes in fashion. And so, in that spirit, about a decade ago, I began a project whose central argument was for Republicans in Reconstruction. The most important provisions of the 14th Amendment were 2, 3, and 4, and that John Bingham aside, nobody cared very much about one. To put one at the center, to say things, for example, as the court does, that the purpose of the 14th Amendment was to constrain the states is ahistorical. Because it doesn't describe what newspapers were saying, it doesn't describe what Republicans were saying, it doesn't describe what anyone other than John Bingham was saying. And my purposes were first an historical purpose, namely to sort of recover a distant past and simply say they have assumptions we don't have. Not easy to translate it into 21st century ideology, and a political science project to suggest we need to stop thinking exclusively about what Constitution means or were intended to mean, but think about how they work. Because in fact, the argument I wanted to say was Republicans mostly thought the 13th Amendment was good enough for all their purposes. The problem was there were structures of government that would permit Democrats to control the meaning of the 13th Amendment. The goal of constitutional reform was to make sure that didn't happen, that our Reconstruction framers are very much like our Federalist framers in their primary concern that if you get the structures right, the rights will follow and the powers will follow. If you get the structures wrong, you'll get the black codes. The black codes cannot be gotten rid of by better language. They can only be gotten rid of by better structures. So I also want to do some political science today with respect to Section 3. And the first thing I want to do is say, good news, presidents, you need not beware. Beware is not the right word. It's not the right word for a number of reasons. First, what we're really talking about at this whole conference, I will suggest, is something the political scientist Ben Ginsberg called politics by other means. When you have two parties that are approximately equal balanced, and pretty much everybody who's going to sign up has signed up, you can no longer win on the issues. So what Ginsberg points up is that while corruption is pretty much a constant in American political life, that people, 10% of politicians say have their hand in the till at all point. We have periods where there are great worries, investigations, impeachments, disqualifications, and the like, and periods without. And these are the periods where politics is equal balance. You can no longer win by making one more person pro-life, one more person pro-affirmative action. All you can say is he's got his hand in the till, she's corrupt. And so it's not a precedent, beware. If we look, everybody is being investigated for everything. Second reason why presidents need not be or beware, I'm not sure it's beware or beware. We can have a debate over that, is that presidents can easily avoid disqualification. Now, with investigation, notice some things that were said yesterday. Presidents who seemingly exercise routine administrative functions get investigated. Presidents say a parking ticket suddenly becomes, maybe it's an impeachable offense. What do you have to do to avoid disqualification? Well, I think the best argument anti-disqualification Professor McConnell made and Marty Lederman make it wasn't an insurrection, it was a riot. It's a reasonable argument. I have arguments that it's wrong, but it might have been first-degree murder, it might have been second-degree murder, but it's pretty easy to avoid instigating a riot. It's not something that presidents, it's sort of like the way to avoid first-degree murder is don't commit second-degree murder. So one may say, whereas for other things we're talking about at this conference, it's a feature of politics by other means, that presidents cannot avoid getting caught up in them, I think it's likely to be very easy for future presidents not to be subject to disqualification if they act like half-decent, not even fully decent, human beings with some sense of patriotic loyalty to the system. And by the way, it turns out even if they don't, presidents need not beware, first because there's an argument out there, whatever we think of it, that in fact presidents are the only people who need not beware of Section 3, that if all you want to be is President of the United States, you don't want to hold any other office, you can do an insurrection and not worry. You want to be dog catcher of Des Moines? No. You want to be president? Beyond that, I'm inclined to agree with Kurt, less as a matter of doctrinal law than as a matter of political science. I think the Supreme Court has closed the door substantially on disqualification. Now, the good news for me is Justice Alito tells me that Supreme Court justices can make egregious arguments that, and I actually think that's wrong, and it's wrong as applied to Alito as well. I don't think that the people in this room make egregious arguments from right side or left side. I think it's a very bad standard. But I do think, if there are egregious arguments out there, Trump v. Anderson counts as one of them, and I've got law review articles saying so, and you can read them or not. But the real bottom point is, granted I get law review publications, we all gotten a lot of law review publications out of this, it's unlikely disqualification is going to be a serious issue. I don't think that it's going to be routinized. I think investigations are routinized. I think impeachments are routinized. I think Congress, the fourth panel, are routinized. This one doesn't strike me. Trump versus Anderson strikes me as Bush versus Gore. It's good for this issue, and it's very unclear what anyone's commitments are for the future. So if we take certain language in Trump versus Anderson, states ought not to be able to control who runs for president. Well, the law of states on the ballot. Just states you have to have a certain number of signatures. You have to have certain things. That also goes, and I'm not sure the court is prepared to do that. The second political science point I want to make, and how much time do I have?
You've got about 8 minutes.
8 minutes. Oh, so I'm in good shape. This is good. I can actually make the point fully. And something that's worthwhile for this conference, we've taken a largely American perspective. But we see, for example, executives under siege in a great many other countries. So it's worthwhile asking, is what is going on in the United States an American phenomena with American causes? Or is it worthwhile asking whether in fact this is a global phenomenon with global causes? So for example, even with Donald Trump, if you start putting, and this is granted my political perspective, you may all disagree, think Trump, Netanyahu, Orban, Venezuela, developments in Italy, developments in Germany, you start to say, aha, there's a right-wing populist or right-wing authoritarian populism thing going out through the world. The causes are probably not specific in the United States. The causes are probably global. And here the first thing we learn from a global perspective is there's nothing particularly unusual about disqualification per se in American constitutionalism. Pretty much every other Western constitutional democracy, and every other constitutional democracy, period, cross out the Western, has disqualification proceedings. Most of the world was hoping Trump got disqualified, and they didn't think, aha, this is undemocratic. They thought disqualification is a democratic procedure. They thought so for a great many countries are committed to something known as militant democracy. And for a long time, I thought, hey, look, we found some militant democracy in the United States. Section 3 of the 14th Amendment, I now think that's wrong. And so I officially want to recant. Kurt said, in fact, we're still learning. I'm pretty confident on the substance of Section 3, but I do think my comparative analysis of Section 3 is wrong, and I'll just suggest a couple of reasons why. For those who need a refresher, militant democracy is the view that there are scope limitations inherent in the notion of democracy. What the people can vote on should be limited by the nature of democracy. So you can vote to raise the taxes. You can vote to lower the taxes because, in fact, democracy does not depend on the tax rate. But you can't vote to get rid of free speech. This is sort of a margin of appreciation that, yeah, democracies can decide how much hate speech we want to ban, but democracies cannot ban, you can't criticize the chief of state. And in fact, militant democracies come with a number of features, restrictions on speech. They come with disqualification. They come with another feature that's somewhat alien to the United States. Namely, in a great many militant democracies, there are limits on constitutional amendments. Again, you can amend the Constitution to raise taxes, lower taxes, but in fact, a court can declare a constitutional amendment unconstitutional if it's inconsistent with the basic democratic structure of the Constitution. So, for example, in countries where presidents want to suddenly serve for life, Kenyan Supreme Court says, no, that's inconsistent with the basic structure of our militant democracy. So at some point I thought, see, look, Section 3, we've got disqualification too. We're just like France. And the first thing that should have told me that I was wrong is we don't have the rest of the apparatus. So isn't it a little weird that while we have disqualification, we have in fact the broad notion of free speech? I suspect for many of you who are not comparatists, who don't follow Kenyan politics, or for that matter, German and Indian politics, the notion of unconstitutional constitutional amendments was a new one to you and one you thought was absolutely bizarre. Only a professor and probably a political scientist could think of it. We don't have the apparatus. Second, if you look at where disqualification comes from, it looks different than in Europe. So before Section 3, the leading case on disqualification is probably a case called Commonwealth versus Barker. Comes out of New York. Jacob Barker is an extraordinarily interesting person, always interested in political office no matter where. He will show up in New York in a set of fights around Prohibition. Suddenly he's in Louisiana as a figure in Reconstruction. But there's a little problem in New York. See, Jacob Barker is engaged in a duel. And New York law says you are disqualified for public office if you have engaged in dueling, and this is actually rather standard. Other states disqualify you for dueling. But I take it while we're all good lawyers, and so we can probably come up with some democratic connection. Most of us don't think laws on dueling make a country more or less democratic. That's one of the things a 19th century democracy could do or not do. What is a law on tooling about? It's about character. Gentlemen. The sort of gentlemen who should hold public office do not engage in duels. And if we were to look at the other disqualifications of the 19th century, they look like character disqualifications rather than democratic disqualifications. Property, after all, is a sign of character. It's a sign of independence. If you are a property holder, you can vote independently. Again, people are disqualified, as Section 2 of the 14th Amendment suggests, if you've committed a felony. Again, it fits more under character than under democracy. And we might say that, in fact, this is the historian in me sort of likes saying these things, that Section 3 is not a product of militant democracy, a notion first popularized by Lowenstein in about 1938. It's a product of Republican democracy, where if we read the Federalist Papers, Madison is consistently talking about how can we get people of high character into government. And if we read the debates on the 14th Amendment, what are they saying? They're saying these people, they're not simply traitors, that's one thing, they're perjurers. They emphasize that, both in the debates in Congress and outside. They do not have the character to be constitutional representatives. That, and here, to add a little commercial, okay, so the oath, and whatever you can say about the oath, breaking an oath is a sign of character, and we can debate whether we still believe in character restrictions or not. So our policy, in conclusion, and I've gotten the warning, is different, and we might say in Europe. There are certain things you cannot vote on. You cannot vote in some sense to say Jews will not be part of the policy, or Muslims will not be part of the polity. Cannot vote to get rid of free speech. You cannot vote to make the chief executive life tenure. But you can vote for anyone with any character. In the United States, you can vote for any policy, and one of the points I made in disqualification is you could vote for a candidate who said, I have Donald Trump's personal phone number, trust me. Every time I have a decision, I'm going to call Trump, do whatever he does, I'll put it on live tape, you can guarantee it. What at least Section 3 suggests is there's a character restriction. If you take an oath to support, to have an allegiance to the United States, and you violate that oath, you do not have the character to be President of the United States, or for that matter, dog catcher of Des Moines. And one of the real questions I think Donald Trump raises is very much a question of originalism, but it's not original constitutional law per se. It's, do we still believe there is a minimal character necessary to be a government official, or we, as a modern Democrat, believe if you get 50 plus iota of the votes, no matter what your character, you are by definition a fit Democratic official. Thank you very much.
Thank you all. Before we open it up for questions, I want to give you a chance to go back and forth, and let me just toss out a question that might allow you to do that. The Trump versus Anderson decision has come in for tremendous criticism from different quarters, including many originalists who are perplexed by some of his claims and its logic. It sits somewhat inconsistently in its appeal to national standards with the federalism that's inherent in our elections. And so there is a sort of a realist, if you will, take out there that this was really a consequentialist opinion. The court did not want the chaos that would follow disqualification. And that when you looked at the various off-ramps they could have taken, the president's not covered, it's a non-justiciable political question, he didn't engage in insurrection or anything else, this was the least bad option. And so we get sort of an underbaked, under-theorized opinion that has us scratching our heads, and two eminent scholars here, three maybe, disagreeing about exactly disagreeing about what it says. So, I don't know, broader perspectives on the opinion.
Well, I mean, I was having some of this conversation with Kurt over breakfast. You know, election law as a field is not terribly originalist as a whole. If you want to go back to one person, one vote, if we want to talk about the Anderson-Burdick balancing test for rules for access to the ballot, if we want to talk about guarantee clause, I mean, there are a lot of areas where the court's jurisprudence has long been pretty pragmatic and consequentialist. So that's its own way of thinking about things. I will pick up maybe on one point, though, and this is sort of in response to a point Mark raised, but one that you also raised, Jane, about this sort of different standards issue. And I know this is an issue that's raised late in the opinion in Trump v. Anderson, saying, wow, we have this patchwork quilt, how could we have all these different standards for presidential elections? And then that is taken as this sort of like, well, I mean, states have all kinds of different rules, and we're going to see, Robert F. Kennedy is going to be on the ballot in some states, but not in others, right? Isn't that going to be a problem for elections? And I don't think that's exactly what's happening, and I think, again, the opinion is a little underbaked and not explaining the problem, right? The problem is there's a federal constitutional standard of disqualification put into the Constitution and is being implemented disparately across the United States. In some places, it's not going to be implemented at all, and in some places, it takes a one-day hearing in Maine in front of the Secretary of State, and in other places, it's a week-long trial in front of a Colorado judge. And maybe that's fine. Maybe we're okay with that. Maybe we're not okay with that. But for the procurement opinion, at least, the notion that you have this fixed federal standard being implemented so diversely across the United States just sort of created a fundamental problem in contrast to Congress's authority to enforce it and to provide that legislation, to provide the unanimity. For everything else, right, the Constitution is very explicit that states get to direct the manner of appointing electors. And there's all kinds of procedural rules and manner rules, and that's where the patchwork happens. And that's okay. And the court's very clear that's okay, with some outer bounds in Anderson versus Celebrezzi and others, right? But the notion that states can do things differently is perfectly okay. The notion that states can do something differently with one uniform standard, with one rule fixed in the Constitution, is where the court gets concerned. Again, I think that portion of the opinion has been used in ways sort of identified by you and others to suggest, wow, I mean, there's some inconsistency. I don't know if there's so much inconsistency. Maybe the court's premise to say, oh, well, states are implementing this federal standard differently as a concern is wrong. I mean, the states implement or enforce the First Amendment at times in ways that could be disparate across the United States and so on. That's a different conversation. But I do think there's something fundamentally different about this provision as opposed to other kinds of myriad ballot access questions.
In terms of the originalist aspect of the opinion, we don't have 9 originalists, of course, on the court, and so if unanimity is important, if you want to have an opinion that has been signed on by justices associated with different sides of the political spectrum, it's not going to be an originalist opinion. And so, yeah, it was very thin, structuralist kind of point, and it is very weakly stressed by the majority per curiam. In fact, when you get to that part of the opinion, it's kind of like, and also if you think about it, it would be problematic to have states making this decision. And then you get the concurrences saying, that's the point. That's the biggest point. That's the only one that we should be talking about. So I think it was inevitable that if you were going to go for a unanimous opinion, that it was going to be non-originalist. Now, I'm not sure what the criticism is that you're referring to beyond that. because the majority opinion, the per curiam opinion, I think was quite originalist and is really follows general originalist investigation of text and early statements and early understanding of the text, with citations to the people who are actually engaged in the creation of that text. I would have, in my own work as originalism, I think it would have been great if they would have gone further and talked about some discussions that happened during the ratification process. But as originalist opinions go, I think the per curiam actually did a good workman's job under a tight schedule. And let me say one more thing. I think one of the themes that emerged over this last year is that there was no originalist argument for saving Donald Trump from being disqualified, because the Baude-Paulsen brief was so exhaustive in its analysis by two conservatives, who, being conservative, they must be originalist. And one of the reasons why I got into this game after Rick Hasson pushed me into it, is that the Baude-Paulsen brief was being treated as an originalist argument, and it's not. There's no originalism in the Baude-Paulsen brief at all. There are a couple of footnotes that acknowledge this. There's no discussion whatsoever about the framing of Section 3 in the Baude-Paulsen brief. There's no discussion whatsoever on ratification discussion. That's where you start in originalist investigation. It was a textualist analysis that they claimed would be consistent with the original understanding, but they hadn't engaged in any originalist investigation on their own. That's one of the reasons why I decided to get involved, because I'd done some work on the history of the 14th Amendment, and I thought, well, okay, what do we get if we actually look at the framing? What do we get if we actually look at the ratification debates? And I gave it my best shot, and I was pleased that they came out with an opinion that at least is consistent with my understanding of the history. But I guess I'd kind of push back. If we're talking about the per curiam, I don't think it's a bad originalist effort.
So I was thinking about Michael Rappaport, who called it an originalist disaster, or a disaster for originalism. I'm not sure in which order it went, and you may disagree with him, but
Sure.
Go ahead.
First, I should note here, I'll agree with something Philip said yesterday. There's no doubt in my mind that 9 justices had a good faith belief that the constitutional order would be better if states didn't do this. I think for a number of reasons, in part the rush to get the opinion, once again a good faith belief that you needed to do this, that they didn't fully consider two things. The first is, was this consistent with everything else they've been doing? This is the question of state laws disqualify presidential candidates all the time, witness Ohio and Biden, that there's no effort there. A second is that Section 3 comes upon them, surprisingly, and unsurprisingly, given I suspect everyone in this room but me thinks 14th Amendment is primarily about Section 1, they viewed the 14th Amendment, Section 3, through the lens of Section 1, through the law of Section 1. So let me give just one brief example from the ratification. Senator Howard, in introducing Section 5, says it's the responsibility of Congress, not the Supreme Court, which is almost never mentioned explicitly in the debate. It's the responsibility of Congress to correct the unjust legislation of the states. So if we read that, what we would say is, yep, if states start disqualifying candidates and Congress doesn't like it, they can take care of it, not the Supreme Court. But that's not what we've been doing historically for Section 1. And I think, naturally, having the Supreme Court as the new police officer, we do it for Section 1. We do it for Section 3, though Howard's remarks, which gets repeated over and over again in the ratification process, indicate that's not what people thought in 1868, that we did not want the police officer to be the judges who voted for Dred Scott.
Okay, let's open it up to questions from the audience. Please go over to the...
I'm going to hold a past mic, so I'll walk around and if you just raise your hand and I'll come over to you.
Oh, thank you. Great panel. I just wanted to ask a question if any of the members of the panel had thought in, previous times to the present that when I looked at Bill Clinton as President of the United States, I kind of felt that they were looking for a candidate that they could control because they could put positive or negative on next week's Time magazine. He was controllable. And I think that, is there a possibility that political elements are simply looking for a way to better control the president?
You're the political scientist.
In one sense, the answer is it's got to be yes in the following way, namely interest groups, political movements. That's what they do. They try to find ways, I wouldn't use the word control, I'd use the word influence, but heavy amount of influence. But it's not simply Clinton. This is what politics is an effort to control different branches of government. The best politics is an effort to control different branches of government to pursue a public good. The worst is it's an effort to control different branches of government to pursue narrow self-interest at the expense of the public good. But politics is about getting control. We can talk about better forms of politics and worse forms of politics. We can talk about better forms of constitutions and worse forms of constitutions, but we can never get rid of politics, nor would we want to.
Is this working? Last month I gave a talk to the Second Circuit, the Hands Lecture, and much of it was about whether or not we could repeal the Bill of Rights through an amendment. I don't think we can, and if you'd like to read that lecture, please contact me, I'll send it to you. Instead, I want to just tell you a story. During the war, Kurt Gödel, the logician who was at the Institute for Advanced Study, decided he wanted to become a citizen. So he studied for the test, and he was taken to Trenton to be sworn in by his two closest friends, Albert Einstein and Oscar Morgenstern. The court has been alerted that these celebrities are going to appear, and so the three were taken right in before the judge and seated at the witness table. Einstein on one side, Morgenstern on the other of Gödel. Gödel stands, and he's questioned by the judge, who's reading a series of questions. At some point, the judge says, "Are you prepared to swear that you will defend the Constitution of the United States?" And Gödel says, "Yes, I am, although it has some flaws." Einstein says in German, "Shut up, Kurt." The judge says, "Flaws? What flaws?" And Gödel begins to give an argument like the idea that you can amend away parts of it, because he's thinking about the Enabling Act in Germany that destroyed Weimar. Einstein begins pulling on Gödel's coat to try to force him to sit down, and he's struggling to keep standing up. The judge decides intellectuals are all crazy, and he just swears him in.
So there's another qualification for presidency, which is, I think, ambiguous, which is the natural-born citizen requirement. We've had, George Romney was born in Mexico. I think John McCain was born in Panama. Ted Cruz was born in Canada, I think. How is that enforced?
What was that? Is that what?
How is that
How is it
enforced?
enforced?
Okay, is that, yeah.
Right. So again, I think it can be enforced by the counting clause if Congress chooses not to count votes. For those provisions, I've written extensively previously that states do have the authority to judge the qualifications of candidates who they deem not eligible. They have done this in the past when it comes to, so Roger Calero is a socialist Workers' Party candidate born in Nicaragua. Peter Lindsay is the Peace and Freedom Party candidate who was 27 years old when she ran for president and kept off the ballot in California. Eldridge Cleaver was 33 years old in 1968 when he tried to get on the California ballot and was kept off. So we have some of these areas where states have been the place to enforce these with respect to ballot access rules. But part of this is it's an anachronism to think about enforcing it through ballot access rules. For 100 years, states didn't print ballots. The parties nominated candidates. The parties would print the tickets, or before that, they wouldn't print the tickets. People would show up and cast their votes for the electors they wanted. So the notion of the state stepping in as enforcer is relatively recent vintage. And then even further, the state as enforcer of disputed factual qualifications is of the most recent vintage. When Eldridge Cleaver is 33 years old, and it acknowledges to everybody he's 33 years old, it doesn't take a lot of work for the California Secretary of State to say, we're keeping your name off the ballot. When somebody shows up to court and says Barack Obama was secretly born in Kenya or Indonesia or something, there's a factual dispute. It's not a good one. There's a factual dispute that the court can look at. But this is the only other case that I'm aware of where there was actually a dispute of fact trying to enforce it as a ballot access restriction. So it's not a direct answer to say, historically, there never would have been enforcement because the states would have had no power over the ballot. It would have been left to Congress and the electors and the voters. And then in the modern era, it has been enforced for presidential candidates, but those have typically been up to the state's discretion. They've let ineligible candidates on the ballot. Sometimes they've excluded ineligible candidates. And all of those cases have been where there's been no factual dispute. No investigation. Now, there could be some factual dispute in the future that's non-frivolous for some other natural-born citizen candidate, where we sort of wonder where they actually are, where they were born or not. Questions like Ted Cruz and John McCain were pure questions of law. They were not questions of fact. And so that's kind of where we are today. And the court in Trump v. Anderson, and Justice Barrett was pressing this at oral argument, was to say, well, what's the source of state authority? And they sort of fell back on Article 2 of the power of the states to direct the manner of appointing presidential electors. And in Trump v. Anderson, they say that we don't think that Article 2 power translates to the 14th Amendment for all the reasons that Kurt set up as the structural matter. But I will point out the strange thing about this case, and there are a lot of elisions in this case. This is a presidential primary, not a general election. The Supreme Court has precedents stretching back to the 70s saying primary elections are not covered by Article 2. They've said parties have control to ignore what states do with primary elections. So there's a separate layer of weird things happening that are just glossed over in this case, just assuming whatever we're talking about is really a general election, and that's what we're going to talk about in this case.
Derek, I wanted to engage you on something, and it's kind of related to Michael's point. That, Michael, my first thing would be there are qualifications and there are qualifications, and some of them are already hard to enforce, so let's not add another one. But if beyond that, in thinking about this particular qualification and how we might enforce it, I know there was a lot of discussion in the briefs as to whether or not this was a simple disqualification or whether or not this was a punishment or a penalty. And a lot seemed to turn on that. At least the authors of the briefs believed the lot turned on that. And Baude and Paulsen believed the lot turned on that characterization. Because it seemed to suggest that if it's viewed as a penalty as opposed to a mere qualification, then some type of process, some type of promulgated process would have to be in place. So your reading of the majority opinion is that maybe the concurrences are over-reading it, that maybe there was a stricter draft down the road, but they pulled those words out. But they did describe Section 3 as imposing a severe penalty. So I just wondered your thoughts on that, because I read that as then pushing towards the need for some type of promulgated legislation, and I just wondered your thoughts on it.
Yeah, I don't know how much work that does. I mean, maybe to relatedly Mark's point about thinking about the kinds of character issues we want in office holders in ways beyond just those simple qualifications. It is different than the other qualifications enumerated in the Constitution. There's no question about that. But again, I come back to thinking about how Congress refuses to seat members in the House or the Senate who it deems not qualified. And we can say that that's a penalty. And it's happening pursuant to the precedents that each House has built up for itself about how it judges qualifications. But it's engaging in the same kind of ordinary exercise of its judging authority in its refusal to seat members it deems not qualified. So while I recognize that characterization of this disqualification is different from the other kinds of qualifications, functionally, I don't know that requires a different kind of process beyond some kind of process, which Congress has developed to exclude members, and likewise, Congress could do if it refuses to count or engage in impeachment or whatever it might decide.
There's an interesting literature on how much of 14th Amendment jurisprudence reflects not the most rabid racist Democrats, but say a Reverend E. Johnson, the moderate racist. You know, I'm not going to join the KKK, not going to prosecute them either, but that, and Democrats to a person called Section 3 a penalty. Vast majority of Republicans did not. There are exceptions. One of the most notable exceptions is Chief Justice Chase, who was not a member of Congress at the time, and probably as important was writing letters to Congress saying, get rid of Section 3. Because remember, one very important feature of Section 3, and this once again is said in the debates by Senator Howard and others, if treason requires a trial in the place where treason occurred, we're not going to get a whole lot of treason convictions in the South. And so, in fact, treating, as Howard said, with respect to the Second Confiscation Act, treating this as a criminal penalty means it's dead in the water.
So I'm curious, are there other areas where we require Congress to specifically invoke a power in order to exercise that power? Normally under Section 5, Congress passes a piece of legislation, let's say the Family Medical Leave Act, and then the government lawyers can defend that act as applied to state governments under Section 5, even if Congress never said anything about Section 5. It seems a bit unusual to require a statement about the invocation of a particular congressional power in order to then exercise that power. So are there any parallels that we could draw here, and are there any historical indications that that's the system that the framers of the 14th Amendment set up?
Just to quickly clarify, are you talking about the need, the alleged need for them to have added a power enforcement to Section 3 itself, as opposed to Section 5?
Yeah, I mean, the way I read the majority opinion closer to the way you read it, the per curiam, which is to say there actually needs to be some invocation of a power to enforce Section 3, that you can't just have the application of a disqualification. You can't recognize disqualification pursuant to any number of other ordinary legal mechanisms for challenging governmental action, let's say a challenge to administrative action, or even potentially the Electoral Count Act, because you actually need to specify this is the mechanism by which we are enforcing Section 3. I take that to be what the per curiam is saying, which I think you are saying also,
I think so
Kurt.
too. I think you're right.
And my question is, that seems unusual as a matter of constitutional law. Like ordinarily, we do not require Congress to invoke a power in order to exercise that power.
Right.
So should I be thinking of this as unusual, and is there any historical indication that we should be thinking of it as unusual for some other reason? Thanks.
I just think that's right. I think it is unusual, and that could be an argument against it, against that particular kind of reading. Some of the Mark might have some thoughts on this. It's my understanding that Section 2, which Mark has done wonderful work on the 14th Amendment, that Section 2 was only going to work by way of congressional legislation in terms of census taking, and that is, Stevens talked about that as well. So that might be kind of, another example. But I don't think there are a lot of analogs here, and the claims about needing that type of enforcement is unusual, sui generis almost. I think you're right.
Any final thoughts?
Can I ask, Kirk, can I ask about so the opinion repeatedly refers to federal office holders. It kind of makes this repeated invocation of federal office holders and candidates and so on, seemingly subsuming the president inside of this without making that determination. So I just wondered about your reaction, given you seem to believe maybe Justice Jackson, or maybe leaves the door open for further suggestion the president's excluded.
Right. And boy, did we battle that particular issue in the months prior to the court's decision, thinking that there was going to be a lot of discussion about it, and the court avoids it altogether. And I guess I should start with my bottom line. I have some intuitions about it that are based upon the historical evidence, which led me to write an article that said there's enough evidence to make this confusing, and so therefore we should treat it as an ambiguous clause right now. I don't know. I think I need to do more research. What I presented in my article is that there were good textual reasons to read Section 3 as excluding the president due to the phrase "under the United States." And there were President Mark has written about this, and Mark and I have gone back and forth about that clause, that it seemed to be associated with offices other than the President of the United States, but there are arguments on both sides of that. You could read the reference to all offices, right, civil or military, as including the President, but on the other hand, you don't have to read it that way, because if you read the section as a whole, it seems to be telling you that the high federal offices are enumerated, and those are the ones that are under state control. And so the structure of Section 3 could reasonably be read to exclude the president, because we're not going after the national electorate, we're going after the local electorate. But that is just one way of reading it, and I think it is completely reasonable to read those general references to offices as including the President of the United States. And my research on the issue is just beginning. We've got about another 150 years to go before we can say anything more.
All right, join me in thanking our panel for a great presentation.
Thank you, Gary.